Yeah, so thanks everyone. Thanks for joining us for today's session on everything you wanted to know about holidays, annual leave, holiday pay, etc. We'll be going through a few of the, or most of the kind of most common questions that we receive about this topic. Most of you on the call have attended one of these before, so you know kind of how it works. We try to kind of take you through the key questions, key areas. Some of it might be quite simple, stuff you're familiar with, just as a reminder. Other parts of it could be getting to a bit more complicated issues, and hopefully we can pass on some of our practical experiences, some of our practical tips as well. And of course, we like to keep it as informal as we can, as interactive as we can. So if you do want to raise your hand, type any questions in the box, or ideally stick your mic on and ask us some questions, we're happy to do that and move into any areas of discussion. There'll be time at the end for questions as well, and we can cover anything there really. It doesn't just have to be the topic of the day. We can also jump into any of your other HR employment law questions. So without further ado, moving into our topic today, as I'm sure most of us have experienced, the legislation and rules surrounding annual leave can often be really difficult to interpret, and it can be subject to quite a lot of change and flux depending on new legislation, court decisions, things like that can change our understanding. So today we'll try and outline in plain terms some answers to the queries we're asked about most often. Now, the right to time off work in the form of holidays may arise under contract, and it may arise under statute, or a little bit of both. Now, holiday benefits both employers and workers by allowing workers a period of relaxation and recuperation, and this right can also extend, or does also extend, to agency workers once they've been there for 12 weeks or more. Now, one of the simple questions we often get asked is, well, what exactly is everyone's entitlement to annual leave? How much holiday do people get? And the answer to that is that the full-time employees have the right to 5.6 weeks, or in terms of days, that's 28 days for a full-time member of staff, and that's an entitlement to paid annual leave each year. For part-time employees, their annual leave, their entitlement is the same, but it's calculated on a pro rata basis. So what does that mean? Well, it means that effectively you need to multiply the number of days worked per week by 5.6. And that means that if, for example, an employee works 3 days per week, they'll be entitled to 16.8 days of paid annual leave. If someone works 4 days, it'll be 22.4, and so on. Even though we're talking there in days, actually often the best way to think about annual leave is more likely to be in terms of weeks, and that can be easier for full-time employees. But when you're talking about part-time employees, part-time workers, it may be necessary to get into calculations on a day basis, if that makes sense. Now I'm just going to pass over to Julie, who's going to take us through how the entitlement to bank holidays works, which has been a particularly relevant factor this year, given a couple of extra bank holidays that have slipped into the diary compared to previous years. So I'll pass you over to Julie now to take us through.
Yeah, thanks, Gareth. We have had a lot of questions this year about generally paying for bank holidays, and in particular paying for these kind of unique bank holidays that have popped up recently and may of course pop up again in the future. So do you have to pay your employees for bank holidays? Well, ultimately the question is answered by looking at the contract. So an employee has a legal right to holidays, but not to bank holidays. So often employers will count bank holidays as part of the statutory 5.6 weeks. So what you can have certainty in the contractual clause. So some clauses will say that the employee is entitled to 20 days holiday per annum plus bank holidays. So if it's as wide as that, plus bank holidays, any bank holidays that pop up, even unusual ones, and we've obviously had a couple recently, but even thinking further back, I think we all got one for Kate and Will's wedding, so that would be included. However, if the contract states that you're allowed 28 days, including all bank holidays and public holidays, then the unique and extra bank holidays don't become that employee's entitlement. The employee wouldn't be entitled to that. Some other contractual approaches are to list the bank holidays that employees are entitled to. So Christmas Day, Easter, Monday. That also would then mean that the employee would not be entitled to these unique extra bank holidays, usually for royal occasions. And the same rationale applies to wording which says usually observed in England and Wales. I've seen that, and I've also seen even more local, usually observed in I've seen it in Glasgow and surrounding areas, because we used to get something called the Fair Fortnight. So there are specific local holidays. So sometimes employers want to reflect that, or they want to contract out of those local holidays. So if you put in the words usually observed, you're not having to add in these kind of ad hoc additional days. Obviously, you can have an element of choice for the employee. So sometimes the contract will say 20 days annual leave per year plus 8 bank holidays. So they're entitled to a specific number, and they can then choose the bank holidays that they want to choose. And usually Christmas and Easter are the no-brainers, and then they may pick additional ones, again, sometimes linked to children's school holidays, things like that. And obviously, sometimes you can simply have 28 days leave per annum, and then the employee can decide to choose if they want to use one of their days leave for a bank holiday or not. Of course, nothing prevents an employer from giving the extra day, even if the contract doesn't provide for it. And perhaps, I know that they're talking about the King's coronation next year being on a Saturday, but there may be some Friday bank holiday issue. So if you decide, if your contract doesn't provide for it, but you give it anyway, you should make sure that you make it clear in writing that it's a one-off. So quite a lot to think about for these bank holidays, but they have caused a problem this year. Not necessarily a problem, but it can be an expensive extra, and obviously employers want to know where they stand. So I'll pass you back to Gareth to focus in particularly on the issue of pay and annual leave.
Thanks, Julie. Yeah, and just before I do that, bank holidays can be complicated. Entitlement to bank holidays can be complicated in relation to part-time workers as well, and making sure that they get the same pro rata entitlement to bank holidays compared with their full-time colleagues. And that can be tricky where, a lot of bank holidays will be Mondays. And if someone's part-time hours mean that they never work on a Monday, working out how you calculate their entitlement to pro rata entitlement to bank holidays can sometimes be tricky. And obviously then bank holidays can fall on a Friday for Good Friday. Christmas and New Year's Day can be different from year to year. So that can throw up an extra element, obviously to be assessed on a case-by-case basis. But yeah, you want to be making sure that inadvertently you're not causing part-time workers to miss out on their overall holiday entitlement just because of the days that the bank holidays fall. So moving on to just an introduction to kind of pay during holidays. Workers with fixed working hours, that's going to be quite simple. Holiday pay amounts to what they would normally be paid during their holiday. So someone takes a week off, they'll just get paid a normal week's pay during that time, and that's fairly straightforward because you know exactly what that person's paid from week to week. As with anything, there can be more complicated scenarios. So for example, if an employee's hours vary from week to week, and therefore their week's pay is calculated based on what they work in each week, when they take holidays, you're going to have to do a calculation to make sure you get the right level of pay for that holiday. And it's not just as simple as paying them a basic rate, for example. So in those circumstances, a week's pay is going to be calculated as an average weekly remuneration, including commission, bonuses, etc., that the employee earned during the previous 52 complete weeks. or if the employee's been employed for a lesser period, for the period of complete weeks for which they've been employed, then you count back from the first day of the holiday. So that can involve on a case-by-case basis, running a calculation to work out, okay, this person has variable earnings. When they take a holiday next week, what should they be paid during that time? And working out that average. And we'll come on to a case later in this session that came through recently, which really got into the detail of this type of thing, and shows how important it can be. Now, another factor that we just wanted to cover as well is whether, as an employer, you're able to require employees to take holiday at certain times. Other than kind of Christmas shutdowns and things like that, this might not be something that most employers were familiar with, but certainly during the pandemic times, when employees perhaps were on furlough or they were on long-term periods of shutdown and things like that, making sure that holiday entitlements didn't build up to unmanageable levels was really important. And so many, for the first time in a long time, many employers were exercising their right to require employees to take holiday at certain times. So the mechanism for doing that is that an employer can serve notice on an employee that they need holiday to be taken at a certain time. And as long as they give the employee double the length of the annual leave that they're requiring them to take, then it's perfectly acceptable, perfectly legal for an employer to designate a period of holiday for an employee. So when we say double, it's as simple as, I need an employee to take a week's holiday, so I have to give them at least 2 weeks notice of that. I want them to take 2 weeks, I need to give them 4 weeks notice, etc., etc. Continuing on the topic of what's included within holiday pay, Julie's just going to take us through things like overtime, commission payments, things like that. I'll pass you over to Julie now.
Thanks, Gareth. So this has been an area that has seen quite a lot of case law, and the position essentially is that, as it stands, is that guaranteed overtime should be included in the calculation of holiday pay. So guaranteed overtime, which is where the terms of the employee's contract of employment dictate that an employer pays for an agreed amount of overtime, so must be included within the calculation for holiday pay. So that then means, obviously, what about the position when there's non-guaranteed overtime or voluntary overtime? So overtime which the employer doesn't have to offer, but which employees are obliged to do under their contract, which is non-guaranteed overtime. So the employer doesn't have to give it, but the employee has to do it. It should be included where it's worked for a sufficient period of time. Like, we love these really clear legal terms. So a sufficient period of time to be considered normal working hours for that employee. And there's been some indication, again, from other case law, that means broadly regular and predictable. But this would only apply to the minimum 4 weeks of leave that's established under EU law, because of the 5.6 weeks, 20 of those days are required under the working time regs, and the remaining 1.6 weeks, 8 days, that's UK domestic legislation. So it doesn't apply to that extra 1.6 weeks leave that's provided for by UK regulations. So that's another factor to be taken account of when you're working out the calculation. Commission, as Gareth mentioned, do we need to include that as part of holiday pay? And the answer briefly is yes. Employees' holiday pay must be paid on their basic pay, and any results-based commission, which would vary with the amount of work done, because obviously they don't get the opportunity to earn it if they're on annual leave. So that would also have to be something that's taken into account, and we can help you with the detail of that if that's something that applies to your business. And I'll pass you back to Gareth to talk about holidays in lieu.
Yeah, thanks, Julie. So another thing that we occasionally get asked is whether, rather than allowing employees to take holiday, can't we just pay them in lieu of them? So pay them for the time instead of actually having them take it. And the answer to that is generally absolutely no, we can't do that. The only time that can be done, as we'll all know, is when the employment relationship ends and there's been a level of holiday accrued that's not actually been taken at the time of termination. And when that happens, clearly the employee is entitled to be paid in lieu of the untaken holiday. And likewise, if we flip that situation around, if the employee's taken too many holidays at the time that their employment ends, they can be liable to return or pay back to the company for the overtaken amount. Now, really to ensure that you're able to do that, you want to make sure that's covered in your employment contract and it's very clear that the employer is entitled to do that. So that's the only time when strictly pay in lieu of holidays is allowed. That brings us nicely onto this concept of rolled up holiday pay. And this may be something some of you may be familiar with. Some employers had, or maybe still do, have a practice of paying rolled up holiday pay. Essentially, this involves, as we said earlier, not paying for holiday while the employee is on leave, but paying them an extra amount during the weeks when the employee works. It's not really a common practice in what you might call kind of a normal working arrangement. So someone's got either very set full-time or part-time hours, but maybe more commonly used in more casual working relationships, particularly 0 hours scenarios. Now, it's in practice that the effect of that was really to discourage employees from taking a rest from work, because they actually didn't get paid when they took holiday, and they were actually more likely to get paid when they did work, because the way that the holiday pay was calculated, and we'll come on to a bit more detail shortly, was according to the amount of time that the employee worked, they would get more holiday pay. Now, several high-profile cases in this area mean that the current advice from the government is to avoid this approach and instead pay holiday pay as and when holidays are taken by the employee. So this approach is very much frowned on, even though historically it was common guidance to do this, and even organisations like ACAS would say in certain circumstances this is how you deal with holiday pay for kind of more casual workers. Now, an example of this has come through very, very recently in a Supreme Court case decision, came through earlier this year. Now, in effect, this case was deciding upon how holiday entitlement, but then by default, holiday pay is calculated for casual workers. As we've said, employers who engage casual workers, particularly on 0 hours contracts, they've historically struggled with how to calculate holiday entitlement and holiday pay for part-time workers, and especially those who work at variable hours and who may have long periods of time between the time that they work. So they may go weeks between shifts, or they may be term time workers and things like that. Now, as we said, in terms of rolled up holiday pay, a common method of how to calculate entitlement and also pay was using what we used to call a percentage method. So in effect, what the employee would do was enhance the worker's pay by 12.07% for all the time that they worked. And this was on the basis that holiday was accrued at the same rate as a full-time worker on the basis of hours that they worked. So for every 12.07, well, in effect, for the amount of time you worked, 12.07% of that time was then rolled up into a holiday entitlement. And the theory went that, well, the employee is not missing out because they're getting paid for the equivalent holiday time. But this overlooked the fact that people weren't actually taking holidays, which is what the working time regs were designed to do, to ensure that the necessary rest and recuperation was taking place. Now, as we said earlier, this was an approach that was recommended by ACAS, but despite that, the legitimacy of the approach was long debated. So many employee reps would argue that it didn't give workers in that position the full entitlement to holiday and rest and recuperation that everyone else received. And as I say, that's because it sought to provide pay instead of actual leave, actual time away from work. Effectively, it discouraged casual workers from taking time off, which would be unpaid, and instead paid them more for when they actually worked, again defeating the purpose of what the working time regs were there for. Now, that whole concept was challenged in a recent Supreme Court case, and the decision came down in favour of the workers, and now confirmed that the percentage approach to calculating holiday pay for casual workers is unlawful, and that all workers are entitled to a statutory minimum of 5.6 weeks paid leave per year, and to be paid a week's pay for each of those weeks of leave that they have. So for a worker with variable hours, holiday entitlement and therefore holiday pay needs to be calculated according to the average weekly hours they worked during the 52 weeks they previously worked. Now, in this calculation, any weeks where no work is performed is discounted. So that means that the employer needs to may in some cases need to look back even further to get enough data to calculate the average. Now, they only need to look back for 2 years or 104 weeks, but they need to go back and discount any times when the employee or the worker didn't work. And that was a significant detail in this case because the employee in question worked only during the term time, and there were big chunks of time where they didn't work, and that skewed, the employee said, it skewed their entitlement to holiday time off and also to holiday pay, and that was rectified in this Supreme Court decision. Now, this kind of decision is going to be particularly relevant to seasonal businesses or hospitality businesses, perhaps, where they may have workers who only work during certain parts of the year or more workers that work during those times. So, for example, the summer or festive periods, and who may have large gaps between the periods that they actually work. Now, if those workers remain engaged during such gaps, even if they're not working, they'll continue to be entitled to take holiday and receive holiday pay based on the previous weeks they actually worked. And in many cases, this is likely to result in a greater entitlement than the 12.07% calculation that was previously used. So we've been talking to a few clients about different options of how they deal with this. There's not necessarily any perfect solutions because it is a big shift in terms of how some businesses have calculated holidays in the past. And the options that potentially we've been discussing include that where you may be engaging people seasonally, then maybe you might want to start looking at using fixed term contracts that end the engagement at the end of the season and then tally up the holidays on termination so that you can use that opportunity to pay in lieu of holidays at the time when it's lawful to do so. As we said earlier, when an employment relationship comes to an end, you can tally up the holidays at that time. Now, whether that's a viable option will depend on how easy it is to replace that worker the next time you need them, or whether they may have kind of moved on to a different employer and make recruitment difficult. And the other example or the other option that we've been discussing is making better use of an employer's right to instruct the worker to take holidays to avoid this building up into a very costly holiday entitlement that needs to be paid at the end of an employment relationship. So if you think you might be affected by that decision, there's a lot of detail to it, quite hard to cover in this session, but if you think you might be affected by that, it's probably one for us to pick up offline and have a chat about the specifics in more detail. I'm just going to pass you back now to Julie, who's just going to take us through a few more last FAQs that we have that we typically get asked about when it comes to holidays. So I'll pass you back to Julie now.
Thanks, Gareth. And I saw a question from Gary there asking essentially if it would apply to bank workers, workers who essentially you have a bank of employees that you call in maybe when you need extra staff or whatever, effectively 0 hours workers. And you said if they're on a bank contract with more than one employer, would they be entitled to 5.6 weeks from each employer? So, well, certainly, yes, it does apply to the type of worker that you're describing, bank workers. And I think it probably would apply to each employment individually.
It would. They'd have the same entitlement across various employers. So it would. And it definitely would fit with those types of employees. That's exactly the type of employees or workers that it would apply to. And so the issue there is to really work out what's the status of those individuals during the times they're not physically carrying out work for you, because they can be continuing to accrue entitlements, and that can be building up during that period of time when they're not working. But then when they come to take that holiday, it will be based on the earnings that they received when they were actually working. So those are the kind of groups of employees where you want to be making sure that, okay, do we want to make it clear that they're not employed in the gap between shifts? Do we want to make sure they're only on fixed terms during busy periods of time that we're working, or are we happy with the status quo? And actually what we're going to do is just keep an eye on the holidays that they take. So as we said earlier, it's not that we can find a perfect solution to this where they get paid less holiday, but it's about managing it better for the business and not being stung, for example, when an employee or worker leaves and they say, oh, and by the way, I'm entitled to a much greater holiday entitlement than you thought, and you need to pay me it now as a lump sum now that I've left. So it's just about managing the impact of that. And so certainly if you're using bank staff, 0 hours workers, just assess how you are calculating holidays and how you are treating their status in between periods of work. But as I say, it's going to be unique to different scenarios. So probably more one to discuss offline if it's a specific concern or a specific thing that you need to review, just to put the right measures in place to kind of limit the exposure of the business.
Great. Thanks, guys. So following on from that, I'm just going to have a look at the issue of employees' entitlement when they're not actually at work. And so there are a few scenarios. Obviously, one of them is if an employee is on long-term sick leave, do they continue to accrue holiday pay? And the answer is yes. Essentially as well, it doesn't even necessarily have to be long-term sick leave. You can be in Mallorca for 2 weeks, and if you're ill and you follow the usual sickness procedures, you can take certain parts of that leave as sick and then have your annual leave at a later date. Obviously, if you have any queries about that in particular instances, you can obviously contact us and we can help and advise you. But the more usual time when that happens is if an employee is off for quite some time. They can continue to be accrue their annual leave, and they can also opt to take annual leave during a period of sickness, and obviously that may affect the amount of money that they're paid. If they're, their annual leave will be full pay and sick leave pay maybe less, and so that's why sometimes employees will opt to do that, but nonetheless it continues to accrue. And the same rules apply to individuals on maternity leave, another similar leave, paternity, adoption leave. And with maternity leave particularly, because that's usually the quite long periods of leave, and perhaps adoption leave, what you'll sometimes find is that employees who do continue to accrue that leave opt to take it in a block at the end, or perhaps at the beginning, but usually at the end of their maternity leave, to help to extend the leave. And also, again, they would receive full pay at that point because it's annual leave. But these are things that can only be done by the employee with you as the employer's permission and approval, but it's something to bear in mind that employees will ask to do it, and they do have that right.
Can I clarify something?
Yeah.
So you maybe I misunderstood, but you saying that if somebody had taken a week's holiday and then they were away for a week, and after 2 days or whatever, they fall sick, they can then say, oh, I don't want this to be annual leave anymore. I want it to be now called sick leave, and I'm going to use those days annual leave that I did have at a later date. Yes.
But don't forget that the sick pay provisions would apply. So that's why a lot of people perhaps wouldn't do it, because they wouldn't receive full annual pay. They would receive potentially a lesser amount.
Yeah. But at our company, they get sick pay, not like full pay. So they could just say, yeah, I'm feeling unwell. I'm on holiday in Spain. And yeah, after the first day I've been sick. So I'm going to do the best I can with this holiday being sick, but I'm off sick and I want those days back as annual leave for a later date.
Yeah.
Oh, wow. Okay.
They can. It's not necessarily that commonly used, because in a weird way, even employees sometimes think that that's a bit of a tricky thing to raise with their employer. And as an employer, you might be saying, well, okay, can we see some sort of evidence that that's the case, if you think there's any doubt about it. But yeah, it came from kind of a European derived case, probably about 5, 6, maybe even longer ago than that now, wasn't it, Julie? And it did send a few shockwaves through, because people were then imagining the worst case Mickey taking scenarios where employees just throw that into the mix to kind of get their holidays back. I haven't seen that much, in all honesty, I haven't seen that much abuse of it. I've seen it happen from time to time, and it usually is really a legitimate scenario. So I haven't seen it abused that much. Employees might not necessarily know that that's the case.
I think the point is that annual leave, and where it meets sick leave, a person who abuses it when they're in Mallorca could similarly abuse it when they're in Manchester. Ultimately the same rules apply. So someone could say, you're perhaps worried that people who aren't ill would say, oh, I might be in Mallorca, but I'm ill now, and so they keep their annual leave for a later date. Okay, fine, but they could similarly do that if you're saying that employees in Manchester, get their full pay, so they could phone up and say, I'm not well.
Yeah.
And still not come into it. So ultimately you're left with an employee who's not at work, and they're saying they're sick and paid appropriately. So I think, as Gareth's saying, it's not something that commonly arises. And when we think of holiday leave accruing during sickness absence, we're normally thinking long term, but just as an FYI, it can work in shorter periods.
We did have a similar-ish thing during the pandemic, when maybe employees were on furlough for a long time, and they continue to accrue holidays during that period of time. And a lot of employers were concerned that, okay, someone's going to have been furloughed, say, for 12 weeks, and then they're going to come back and they're still going to have time and entitlement to holiday, so have more time away from the business, just when I wanted them to come back in and try and build the business up again. And so what a lot of employers were doing was utilizing that right that we mentioned earlier, which was to say, I'm going to put you on furlough during these periods, and I'm going to have you take a holiday during these periods, so I'm going to pay you accordingly, but I'm going to make sure that holiday doesn't build up, and I'm not going to allow that extra period of leave when you'd have been off anyway. Now that's what a lot of businesses did, and it was debated whether that was a completely legitimate thing to do, or it was open to challenge, I suppose, where employee representatives or employee groups would argue, or were arguing, sorry, that, well, if you order me to take a holiday during a really strict lockdown period, I'm not getting the full rest and relaxation and recuperation that the working time reg says I'm supposed to receive. So therefore, that doesn't count as holiday. You can't do that. Now, that was never fully tested. No one's really challenged that, as far as I'm aware, in terms of the courts, but that was being mooted and debated in terms of, can you actually enforce holidays during that period? So you can see that these details come up of people saying, well, a holiday should be a certain type of leave, and if I'm in my sick bed or I'm locked down in my house, that's not a holiday. And so that's a similar kind of idea to this thing around, I booked time off, but actually I ended up being ill, so I wanted to go down as sick leave. It's in the same vein of things, and every so often that will make its way through the courts, and we'll get a decision from the courts, and then that kind of guides what we do. Before then, it's a kind of debate topic and kind of speculate all day long about it. But yeah, it just shows you that there's those kind of things that